Let's do it. Well, welcome everybody to the McMurray and Shuster Marketing Practices and Privacy Laws. Are they on a collision course? And so we have our resident privacy professional, Josh Stevens, who I will be interviewing. And this is a unique format for webinars in that we asked for questions ahead of time. So we'll actually be answering the questions that the public had instead of just providing information that we think is important and is interesting. At first, I need to give a disclaimer. While we are lawyers and while we will be talking about legal topics, we are not providing legal advice. And we always recommend that you find an attorney in the area to provide that advice. And obviously, we at McMurray and Shuster are always happy to do that. Our contact information will be on the screen at the end. Also, we are recording this presentation. It will be available on our website in a few days after the presentation so that it can be shared or revisited. So with that, Josh, privacy is a hot topic right now. You know, as I was looking at the FTC's website this morning, on their front page, it says commercial surveillance and data security. And it says that the FTC is exploring rules to crack down on commercial surveillance and lax data security practices. And they're even going to be having a public forum on September 8th, which I'm sure if you go to ftc.gov, folks on this call can join that via a webinar link. But you know, just broad picture here, Josh, what's going on out there on the federal and state level?
Yeah, there's a lot happening. And I also just want to tell the audience that while we do have the questions from the audience that were pre-submitted, you can submit questions there's a Q&A box at the bottom. You can submit those. We'll be watching for those and answer those as we go through. But yeah, there's a lot happening. Let's start at the federal level with privacy work. Some of you may have heard of the American Data Privacy Protection Act, the ADPPA. This is a bill that's pending before Congress that would establish a nationwide general privacy regime, which is not something that our country has. We have a lot of sector-specific laws like GLBA for finance or HIPAA for healthcare, but we don't have a general privacy law. And the ADPPA was passed out of committee in the House of Representatives by a wide bipartisan vote, 57-2. It's currently pending in the House. And this bill would do a number of things. It's very similar to the California law in that it would give consumers certain rights over their data. It would require that businesses process data under a fiduciary obligation, so under a duty of trust, which is a real change from how we've seen these things in the past. But it also has a private right of action, which I know has gotten a lot of people concerned, and myself included. I think privacy is an area where a private right of action is very worrisome because things are not black and white in the privacy world. And so whether this bill will pass or not, who knows? But one of the big pieces of it is that it was going to empower the FTC to do rulemaking to help implement the bill and to establish additional privacy frameworks. Well, I guess the FTC decided they weren't going to wait. And so last week, they announced an advanced notice of proposed rulemaking. Gotta love all the long terms in government. And this opens up a 60-day comment window where they're seeking information on a number of different privacy practices. Michelle, what you were just talking about with the cybersecurity, lax cybersecurity being a key piece of that. This is the first step in the rulemaking process. I like to think of this as kind of like an RFI. They're going out to the public with a lot of questions, and they're just looking for some information. Then they'll take that back in and they'll work on an actual rule that then will go back out to the public for a comment period when you actually have text to look over. And we're probably still a ways away from that. But this shows that the FTC is not waiting on Congress. They're going to use their general UDAP authority that's unfair and deceptive acts and practices, to regulate this space, whether or not Congress steps in. And so definitely a few things to watch there on the federal level. And then at the state level, 2023 is going to be a huge year. January 1st, we have the California Privacy Rights Act coming into effect. And throughout 2023, we have additional privacy regimes in Colorado, Connecticut, Utah, and Virginia. So we're seeing now what started with California, 2 years ago now in 2020 is now starting to bleed through to other states. And the feds are looking at it for inspiration.
Yeah, it's an active area. In our office, we monitor for new legislation every day and review cases that are filed as well. And this has been an area that's been extremely active. Speaking of which, I think there was an interesting case that was filed in Ohio that piggybacked on not piggybacked isn't the right word, but used the same concept that was used in an active prospect involved case regarding monitoring of keystrokes as a consumer was entering information. Do you want to tell us a little bit about that?
Sure. So I guess a little over a month ago now, the Ninth Circuit allowed a case to proceed under California's wiretapping laws against a website that used Active Prospect, which Active Prospect is a company that provides a tool that essentially captures a consumer's interaction with a website so that you can prove that that interaction happened. So, for example, in the TCPA world, if you're getting prior express written consent, you want to be able to prove that you got that consent. And so their product helps you do that. What happened was the consumer claimed that under California's wiretapping laws, the use of this third-party tool, the Active Prospect tool in this website, was essentially allowing a third party to wiretap a communication between the consumer and the business. And the Ninth Circuit allowed this case to proceed. I think there are still a lot of open questions when you read the opinion. I heard some people sort of say, "Oh, this is the end. We can't ever have anyone use a tool in a website to capture anything ever again." I wouldn't go quite that far yet. I think there are still a lot of open questions, but what we're now seeing are copycat cases. And so, for example, the case Michelle was just talking about was against a jewelry company here in Ohio that was filed by a pretty well-known plaintiff's firm out in California. California consumer went on their website and they had a tool built in that captured the keystrokes that the consumer put into the site. And so under this same theory, they're claiming that this was a wiretap. And I expect we'll see more of these copycat cases until this kind of gets squashed or, we get more clarity. So for any people out there who have tools built into their websites that capture consumer interactions, definitely something to think about and talk to your counsel on ways to mitigate your risk.
Yeah. I think, it's interesting as we've spoken to clients and discussed this issue and how they can avoid potential problems. Would you like to provide maybe a little insight into some of the types of things that would be, best practices for avoiding these lawsuits, which carry a private right of action? And as you recall, it's $5,000 per violation. So it's a hefty fine for a company that could be hit with one of these lawsuits.
It sure is. And one of the things that the Ninth Circuit pointed out was that you can't go back and correct it. So one of the arguments that was raised was, well, the consumer could read the privacy policy and see that these types of tools were used. And then by continuing to interact with the website, they were agreeing to it. And what the court essentially said was, well, no, you had captured information before they did that, and you can't go back and rectify it. So one of the things that we generally recommend is if you use these types of technologies, have a cookie banner or a pop-up that comes up and explains your use of the technology and that the consumer is consenting to its use by continuing to engage with the website. And if you really want to do this right, in theory, the tool, the potentially offending tool, shouldn't engage until the consumer has had a chance to review that cookie banner and close it out or accept it or take some other interaction that evidences their consent. That's really the safer way to do that. I mean, you could go all out and really get their actual opt-in consent and all that. That's probably a little overboard for most websites. But having that type of layering so that they're informed and then they are choosing to proceed, and that's their implied consent before the tool becomes active.
This is definitely one of those areas where an ounce of prevention is worth a pound of cure, because the chance of penalties being so high. I know you've been busy this week also working on filing some comments on behalf of PACE, Professional Association for Customer Engagement, around the California Privacy Rights Act. And tell us a little bit about what the California agency was looking for, and what type of information is being filed now.
Yeah, so today is actually the deadline. If any of you want to get comments, and you have till 5 p.m. Pacific, and you can just email them. So you really got till right up to the clock. But the California Privacy Protection Agency, which is a new agency in California that is regulating privacy law, they took over that job from the California AG's office when CPRA was passed back in 2020 as a ballot initiative. They published about 60 pages of regulations under CPRA and are requesting comments to those regulations. So on behalf of PACE, we've drafted a set of comments. We've focused on a few areas that we think are the most problematic or the least clear. I'll just give you a couple of examples. One is in the regulations, they say that you can't use shaming or guilting language to try to steer a consumer towards making a less privacy protective choice. And one of the things that they give as an example is if you say yes or no, I would like to pay full price, in response to being offered a discount in exchange for your email address, which we've all seen those on websites, right? They're everywhere. And so they say, well, that's trying to guilt the consumer, right? And so our position is, yeah, but there's also an informative aspect that helping the consumer understand the impact of their decision, that should still be allowed. So maybe you don't imply something about the consumer's preferences or about the qualities of the consumer, but you should be able to make a factual statement. So instead of, no, I like paying full price, maybe you could say something like, no, I understand I won't receive the discount, right? So it's more, right. So it's neutral, right?
Right, right.
So that's one example. Another area has to do with language. They had some regulations in there that could potentially have required businesses to translate all of their privacy disclosures into every language in which they interact with the consumer, which is hugely burdensome. So pushing back on that. And one more example with regard to the browser-based opt-out mechanism. Some of you watching may be familiar with what's called global privacy control. This is a technical standard for essentially a signal that your computer browser sends to the website to say, this consumer doesn't want their information sold or shared. And under CCPA and CPRA, you are supposed to ingest those signals and then honor those requests. And under CPRA, these proposed regulations, there are a lot of technical things around that. And if you can do this, then you got to treat it this way. If you can do that, then you got to treat it this other way. And so one of the things we've asked for is for that to be delayed, that portion of the rule to be delayed, to allow more time for businesses to figure out how to implement this technology, and for the agency to provide more guidance, because it's a real technical problem for a lot of businesses. So those will be filed sometime before 5 p.m. Pacific.
All those comments will be public once filed. Is that correct?
Yeah, all comments that are filed are part of the public record in California. I will tell you, though, that with California, at least with the CCPA rulemaking, they didn't publish all of them on a website. You could get them through a FOIA request, a Freedom of Information Act request, but they didn't publish them all on the website.
So not like the FTC or FCC.
Right.
Well, speaking of privacy policies, we have a question here that was sent in advance. It says, I have a comprehensive privacy policy for my website. Does that cover me for all marketing initiatives?
So I'm going to say if it's for your website, probably not. So think about it this way. A privacy policy is supposed to cover all of your collection, use, and disclosure practices. That can be what happens online and what happens offline. So if your privacy policy only talks to your website and about your data collection and use there, it's too narrow. So you probably need to take some time, work with your counsel to expand the privacy policy to encompass every way that your business collects, uses, and discloses data.
Great recommendation. For our lead buyers and sellers that are out there, a question came in. Do these laws stop me from being able to buy and sell data?
No, but so there's always the no and then the but. They do put a lot more parameters around it. So, for example, under the CCPA regulations, if you are selling data to a third party, your contract with the third party has to have certain provisions that are mandated in the regulations. One of those provisions is that you have to define the specific uses that that third party can use the data for. And then you have to retain rights to take action and stop their use of data if they use it outside of those uses. So can you buy and sell data? Yeah. I mean, you've got to honor the opt-out rights, right? Consumers have now this right to opt out of the sale of their data, but and have these contractual provisions, but you've got to be more cognizant about how you're doing it, structuring it the right way, and making sure that you're not going overboard with what you're doing.
So speaking of California, we had a question about the CCPA, and I'll read it verbatim here. What the heck is cross-context behavioral advertising?
Yeah. So cross-context behavioral advertising is like targeted advertising under the other state regimes. They're a very similar concept. This is essentially advertising to a consumer based on the consumer's behavior across different apps and websites. So think about it like this. Let's say you go to a website, let's say CNN, just to pick one out of thin air. And then you go to Kohl's website. And for whatever reason, I don't know why this would be this way, but whatever, a CNN ad is showing up on Kohl's website. That's probably cross-context behavioral advertising. It's probably following you, right, from one website to another. It's monitoring your behavior from one to another. But where we see clients run into some trouble and where the regulations, the draft regulations under CPRA were helpful, is that they clarified that situations where, for example, you send a list to Facebook of consumers and you say, I want to show an ad to these consumers through you, Facebook. That's probably cross-context behavioral advertising, because now you are directing the advertising based on the consumer's behavior, not just on your website, but also on Facebook. So now you're crossing right across websites. Similarly, if you use a lookalike audience, that can be, so a lookalike is when you send a list of consumers to Facebook and you say, okay, Facebook, I want you to take everything you know about these consumers, build a profile of what our best customers look like, and then market to them, show my ads to other people who have similar demographic profiles. And so that's cross-context behavioral advertising too, right? And there it's a little clearer, because now you're saying, okay, Facebook, we want you to pull in data from all these different sources all across the internet and build out these profiles and then market to them. So it's something where, as you're thinking through your implementation before 2023, you really got to get with marketing and find out what it is that they're doing to help move your product forward, and then figure out how that needs to be structured to be able to do it in a compliant way.
That's always good advice to check with marketing and then also talk about compliance. Always good. Again, with the CCPA, and as I'm asking these questions, just a reminder, if you go to the Q&A box at the bottom of your screen in the middle, you can submit questions for Josh or for me, and we're happy to answer those. Chris, that was right on time, so thank you for sending that. What's happening with the CCPA's employee and B2B exemptions?
Okay, so the employee and B2B exemptions, these are two significant partial exemptions to the CCPA. Those are both set to expire January 1, 2023. There were two bills proposed in the California legislature to extend them. One would have extended by, I believe, was 3 years, and another one would have done it indefinitely. Those bills did not move out of their first chamber by the deadline. And so what we're now running up and what we're hearing is that there is an effort underway that will, through some parliamentary maneuvering, hopefully get a 1 or 2 year extension passed before the legislature goes out of session at the end of the month. I can't guarantee you it will pass, but we are hearing that the odds are good and that there's a lot of momentum to try to get this short extension while the legislature figures out what to do with these on a long-term basis.
Seems like we've heard about that a lot with the CCPA, a lot about extensions, and we're most certain that it's going to happen, and then, oh, maybe it doesn't happen, but it still might.
Yeah, or if it does happen, it happens at the very last moment.
Yes.
Yeah.
Let's go to Chris's question. Chris says, I'm particularly concerned about the proposed CCPA's updated regs regarding a company or requiring a company to respond to suspected fraudulent requests with why it thinks the request is a fraud. Engaging with scammers is always dangerous, but it's particularly dangerous to inform them of how they were caught. I've already found many instances of CCPA deletion requests before used for phishing. Do you think CCPA will back down from those changes?
Okay, that's a good question. And I think that this is an area of risk for businesses as they're trying to figure out how do you protect consumer security while also dealing with informing legitimate consumers about why something wasn't done. And so, and Chris, to your question, we've also seen a lot of deletion requests that have come through very dubious sources and trying to use those as backdoors to get information. So we're always telling clients to be very careful in their authentication procedures to make sure that those are done right. Here's what I would say. There is nothing in the CPRA or the CPRA regs that require you to do something that is going to jeopardize your data security systems or that is going to put the consumer at risk. I think what you have to do is you have to have a tailored approach in your responses, which I know that can get burdensome, but tailoring the responses to inform the consumer that this wasn't processed because of concerns of fraud, and maybe at a higher level indicate because we weren't able to verify your identity, right? Or something like that. That doesn't produce it's the government talks method, was it methods and means, or so you always hear the intelligence community refer to, right? Try to avoid that in the response. Stay at a very high level. And I just don't see the CPPA coming down on a business that uses that type of technique because of concerns for protecting the consumer's security. Right? You have an obligation. You have an affirmative obligation on the CPRA to take reasonable steps to protect consumer data. And so that's part of it.
Sorry.
And so I don't see that being too much of an issue. But it is a fine line to draw, and I do think it does require a little bit more manual intervention in your response process than you might like.
Was Siri trying to intrude on our webinar?
Siri was trying to intrude, yes.
This is a good question, and it changes the focus a little bit. You know, obviously we're talking to businesses and we're talking about marketers and compliance and all of those exciting topics, but looking at it from the consumer side, these new privacy laws and regulations, what type of rights are we seeing the consumers get?
So under CCPA, right now, consumers in California get the right to know, also sometimes referred to as a right to access. So they get to know information about what's being collected about them, how it's being used, and they can also request a copy of information of their information. They get a right to delete that has a number of exemptions. So if, for example, if you need to retain the information to manage a data security or prevent fraud program, then that's an exemption, right? So there are ways around that. They also get the right to opt out of sale. With CPRA, and then it varies a little bit between the other states as well, consumers are going to get the right to opt out of the sharing of their personal information for cross-context behavioral advertising purposes. They're going to get a right to correction. So they can come to you and say, well, I just did a right to know request. You gave me this information. This piece of it was wrong. You need to correct that in your files. So that's the right to correction. They're also going to get the right to limit the use of their sensitive personal information to certain uses that are defined in the CPRA regs. What's actually interesting about the sensitive personal information piece is that in a number of the other 4 states, you actually have to get consent to even collect sensitive personal information, which is an opt-in instead of an opt-out kind of mechanism, which can be burdensome. And they'll get appeal rights. So if you deny a consumer their request to delete, let's say, then you need an internal process where they can appeal that. And then under most of the frameworks, you have to inform them that they have a right to go to the AG if they're dissatisfied with the result of the appeal. Oddly enough, California's didn't have the appeal rights, the other 4 states.
Isn't that interesting?
Yeah. Yeah.
Goes much farther when it comes to the consumer rights.
Yeah.
So when you were a seller who's collecting information and you have vendors that are the front line, do you have any recommendations about how to manage those relationships and to ensure that your privacy policies are working their way all the way through to vendors and other third parties that you're working with?
Yeah. So when you're working with service providers, aka data processors, the first piece is the contract. The contract is key. The CPRA regulations have a whole list of requirements of what has to be in that contract. The other states have some requirements as well. So making sure that your contract fits those regulatory parameters, because if it doesn't, not only is that a violation, but that can convert the relationship into one with a third party where you may be unintentionally now selling personal information to that third party, which you don't want to be doing unintentionally. So contract is key. One of those contract provisions is the right to monitor and audit. And so you need to have procedures in place on a regular basis to be monitoring and auditing the data processing activities of those service providers. Now, that may take different forms depending on what they're doing. For a lower risk processor, maybe you send them a questionnaire that their IT team fills out and returns back to you. For higher risk ones, maybe you reserve the right to actually be able to go to their facilities and bring your team and dive into what they're doing and make sure that the data is protected, that it's being used in accordance with the contract, and that your standards are being upheld. And before you ever sign the contract, you should put them through a due diligence process that probably mimics the monitoring and auditing that you'd want to do, maybe even a little more than that, right? To make sure that they have in place the ability to do what you need them to do before you ever share a piece of data with them or allow them to collect data on your behalf.
So let's flip that a little bit. One of the questions that we got beforehand was, how do these laws impact call centers versus brands? And so pretty much talked about brands, the sellers. And so how does it affect those service providers, i.e. data processors?
Yeah, so if I'm sitting in the data processor role, I want to make sure that my data controller is providing all necessary disclosures to consumers to allow me to be able to do what it is that I need to do, that they are obtaining any consents that need to be obtained, and that they are going to be able to handle the data subject requests, the consumer requests that come in, and work with me to fulfill those. Because as a processor, I'm sort of at the mercy of the data controller to fulfill those roles. And so that's what I want to do my due diligence on is, are you complying with the law in your collection of this information? And are you going to be able to work with me in order to fulfill requests?
It's an unusual position. Usually it's the other way around.
Mhm.
Those requests coming to the service provider. All right, we have a question from Chuck, who's asked, my company buys leads from different sources. What should we be asking for to be sure that the lead source has the proper permissions to transfer data to us? Currently, we give live call transfers from the lead sources.
Yeah, so I'm going to assume for purposes of this question that we're talking California, right, which has CCPA in place, or one of the 4 states that are coming up. What you want to do is, in your contract, right, you're going to want to make sure that you've got all the right provisions in there, that you are putting, again, on them the obligation to comply with laws to get those consents. But one of the key things that is often overlooked is that I put in those types of contracts is an express prohibition against them transferring data to me for which a consumer has exercised their right to opt out of the sale of the data. So rather than just a general comply with laws provision, actually making that very explicit and talking to the lead seller to make sure that they understand what that means. Because one of the things that I find in the data broker industry is, especially early in the CCPA days, people didn't like the definition of sale under California, and they didn't like that consumers got opt-out rights. So they tried to twist themselves into pretzels to say that what they were doing wasn't a sale. In fact, just yesterday, I reviewed a contract that was for a sale of data. It's said it right up in the recitals, right, that they were selling data. And then later in the contract, it said that the parties agree that this is not a sale of data under CCPA. Right. So have that conversation with them to make sure they understand what it means, and to make sure they understand that if they are in a resell role, that their job is to police the people that they're buying data from and make sure that by the time it makes it to you, it's still compliant. Because that's another area that we see is where data sellers will say, well, I buy this data from this other person, so I can't tell you whether it's right or not. No, that's your job, right? You are the person selling it to me, so it's your job to make sure that it's right before you sell it to me. So frank and honest conversation.
You know, you've talked a lot about personal or sensitive information. What's the difference between those two terms, and does it matter?
It does. So personal information is the broader term. It's also personal data under the other 4. So California uses personal information. The other 4 states refer to personal data. It's essentially any information that can be used to identify or that can be reasonably linked directly or indirectly with an identifiable person. So where people get confused on this is they'll say, well, I have a zip code. I can't identify someone with a zip code. Okay, but is that zip code in your system where it is tied to a customer record? Okay, if that's the case, now you can link it, right, to a person. So it's personal information. And that people got confused on that for a while, especially early in the CCPA days. So personal information, very broad, very, very broad term. Sensitive personal information is a narrower concept. It's specific categories of personal information. Under each framework, they're a little different, but they're typically things like social security numbers, other government identifiers, race, ethnicity, citizenship, health data, precise geolocation, biometrics, things that if were to be leaked about a consumer could potentially harm the consumer, cause a detriment to them, or could really result in identity theft. And so sensitive personal information really needs to be collected only in instances where it's needed. And that's what these 5 state regimes are really pushing businesses toward, which is if you're going to collect this, it needs to be reasonable and necessary. And consumers get more rights and protections with that, right? In particular, the consent requirement under Virginia and some of the other states before you can even collect that information is huge, right? That is a significant difference. It's much more GDPR like. In fact, the way they talk about consent, it's freely given, specific, and unambiguous. It's a copycat of the terms from GDPR. And so, for those of you who have ever had to deal with GDPR,
what is GDPR?
Like me, you'll know that there's a 40-page guide out there from the European Data Protection Board on what it means to get consent. And it's actually a very onerous process. It's a very onerous concept. And while we don't know for sure that the states are going to take a similar approach, the fact that they borrowed the same language is probably a decent indicator that they may look at it the same way.
What does GDPR stand for, since we're using acronyms?
I think the General Data Protection Regulation out of the EU.
We've talked a little bit about exemptions with employees and B2B exemptions and whether they'll be there. What about exemptions for healthcare? Are there any current exemptions from these state laws that are being proposed? Yeah, so all of the state frameworks exempt HIPAA covered data. And they also exempt GLB covered data, Gramm-Leach-Bliley, that's the financial services law. In the non-California states, there are also just blanket exemptions. If you are a HIPAA covered entity or a GLB covered entity, then you just have a blanket exemption from the law. Whereas in California, it's based on the data. So you could be a GLB or HIPAA covered entity, but then you have certain data that falls outside of those 2 frameworks that could get caught by the California law. So if you're in those areas, definitely work with counsel to figure out what falls into which bucket. Okay. So as we're talking about all of these laws, and I know that we have a large number of performance marketers and lead generators on the webinar. Are there any changes that they need to consider to their opt-in or / opt-out policies as a result of these laws that are being passed? Yeah, so most of, I think what they need to worry about is going to be an opt-out kind of method, right? So consumers having the right to limit the use of their sensitive personal information, the right to opt out of the sale of their personal information, the right to opt out of sharing of their personal information for cross-context or targeted advertising. Be cognizant, be mindful of the sensitive personal information opt-in consent in the non-California states, and think about how you build that into the flows. I don't think this changes anything with like your TCPA prior express written consent. It doesn't change that language, but you may need to have some additional disclosures as well, right? So think about under CPRA, for example, there's a notice at collection. So before you collect personal information, there's certain information that you're supposed to disclose to the consumer, including these rights around do not sell, do not share. And so making sure that that's part of your flow, that you're presenting that information before you start collecting anything from the consumer. And for performance marketers, let me just flag something else for you. I know that those websites like to tend to have a lot of cookies built into them, a number of which are often third-party cookies. Under CPRA,
if a third party collects information from your website and it controls that collection, you have to now, under the draft regulations, disclose those third parties in your privacy policy, or you have to provide detailed descriptions of their business practices. So be mindful of, and I guess really this is for anyone, but I know for performance marketers, this may be a bigger issue, right? Be mindful of those third-party tools and cookies and pixels and other things that you build into websites, because those can get you into trouble if they're not set up the right way.
Just a reminder, if anybody has any questions, don't hesitate to ask those in the question and answer box. We still have a few more questions that were pre-submitted. And one of them is on point to what you were just talking about, Josh, with TCPA consent language. And so do these privacy laws impact what companies are already required to do to comply with the TCPA?
No, they really don't. They're two separate frameworks. So it's all about making sure you comply with both. Right. So it doesn't amend the TCPA. It doesn't change any of the rules or regulations that were issued by the FCC under the TCPA. So that all still exists. It doesn't go away because of the new privacy laws.
I know that there's been some concern about burying privacy policy links in the CCPA language or vice versa.
Yeah.
CCPA consent language and the privacy policy notices. Can you talk a little bit about that and why we want to avoid those types of things?
Yeah, so under the TCPA, prior express written consent has to be clear and conspicuous. And if you, and so remember the prior express written consent has certain things that have to be disclosed. If you take those disclosures and you bury them in amongst lines and lines and lines of other text, whether that's about privacy policies, terms of use, that they are going to get emails and yada, 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 whatever, you are reducing the effectiveness of that prior express written consent language because it's not as clear and conspicuous anymore. So my general recommendation is if you want to line your TCPA, prior express written consent language, and your privacy policy and your other privacy disclosures, set those up so that there's a break between them, right? So you have your TCPA language, and then you've got a line break or two line breaks, and then you've got your other language. That way it's clear to the consumer, right? Here's one, here's the other. That will help improve the clear and conspicuous nature of both of those.
Great advice, but not legal advice, just great advice.
Correct.
Okay, so we have one question left. So if anybody has any questions, now is the time to type those in the question and answer box. And this is an interesting one. It's kind of a different swing on the type of information that we've been talking about. So the question is, can you review the use of publicly available information like permitting, property appraisal data, et cetera, used for marketing?
So under CPRA and under the other four frameworks, publicly available information is not considered personal information under the frameworks. But we have to be mindful of what it means to be publicly available information. So that is, and I'm paraphrasing a little bit here because the language varies a little bit between each statute, but it's information that's lawfully made available by a federal, state, or local government. So let's take property appraisal data, for example. If you're going to use that information and rely on the publicly available exception, then you need to be able to prove the provenance of that language, right? So, or of that information. So you need to be able to show that you got it from a government source in a lawful manner. So where this can run into trouble is some states, for example, have laws that restrict the use of certain government records for marketing purposes. right? Take the Driver's Privacy Protection Act, for example, the DPPA that protects driver data. There are certain uses that are permitted by law. There are certain, and then if it doesn't fit in that category, then it's not permitted. And so you need to be able to know that under the law of the agency that provided the information, you got it lawfully, and now you're using it in that lawful manner. So I think while the publicly available exception is really nice for people who rely on these types of data, being able to prove, right, that prove the source and prove that it was lawful may actually be harder in practice than it sounds. And that's my concern with the publicly available exception.
It's a great point. It's a great caution detail too.
Yeah, we also had another question that came in right before we got on. So I'll pull this one up here because I jotted it down, which is for U.S. companies with Privacy Shield who kept it up despite Schrems 2, what will the benefit be to them when and if a transatlantic agreement is finalized? So for those of you who may not be as up with everything going on with Europe at the moment, Schrems 2 was a decision that came out of the European Court of Justice that invalidated Privacy Shield. Privacy Shield was a mechanism by which US companies could transfer data from the Union over to America in compliance with GDPR, because the European Commission had determined that it provided an adequate safeguard, that it protected consumers essentially like the GDPR did. The Schrems 2 decision invalidated it. The program is still running. The US Department of Commerce is still operating it. Many businesses are still participating. I think the hope is that when a new program is put into place, that the companies that kept up their Privacy Shield registrations and procedures might be able to grandfather into that new program more easily, and maybe have some protections for the period of time in which a program wasn't in place. I can't guarantee that's what's going to happen, right? No agreement has been finalized yet. Back in March, the Department of Commerce announced that they had reached an agreement in principle with the European Commission, but I've not heard much about it since that. And even once one is agreed, I really question whether it will survive legal challenge, because the basis of Schrems 2 was that US national security laws are so broad and all-encompassing that it didn't matter what you put in place in terms of procedures, the government could get access to that data. And so, and there was no recourse. There was no way for a consumer to take the government to court, because the consumer would never know, because the national security laws with FISA, for example, keep that all secret. And so if those laws don't change, I really don't know how another program can survive a legal challenge. And Max Schrems, who is the one who brought that case, has already said that he will most likely challenge whatever is put up next. So, we could have a Schrems 3.
Yeah. Isn't that what is that? That's not a sequel. It's a sequel to the sequel, I guess.
Hopefully it's the end of the trilogy, but.
Well, Josh, such great information and given in such a practical format. I really appreciate it. Thank you. And
yeah, happy to always help. People out there as they're navigating this. It's a tough thing to be navigating, and it's very fact specific. And this is, if I can give sort of a parting thought, which is, as you're working on this implementation, or as a business is thinking through what they want to do next for marketing or data management or whatever it is, bring counsel in early so that you can have privacy by design. right? It is much easier to put in a compliance program before you set up everything else, or to do it simultaneously with it, right? So that they're working hand in hand, as opposed to setting up a structure and then having to go back and bolt on a compliance program. That's a lot more onerous. And it can frankly cause, loss of investment, because you set something up one way and now you got to go and undo it to set it up a different way. So, get out in front of these issues. I know they're big, I know they're scary, but get out in front of them and work through them early.
Great advice. All right. Well, everybody, thank you for joining us and have a wonderful day.